costs $5 to file at your county recorder's office and protects your home from being seized in a bankruptcy, a lawsuit, or a creditor judgment. Not your investment property. Not your vacation cabin, your primary residence, the home your family sleeps in every night. Once this document is recorded, it creates a legal shield around your equity that no unsecured creditor can penetrate up to the full protection amount set by your state. In some states, that amount is $300,000. In others, it is $600,000. In Texas and Florida, the protection is unlimited. Every dollar of equity in your home becomes legally untouchable for the cost of a cup of coffee. The Homestead Act of 1862 gave American families 160 acres of public land for free. But the legal principle behind homestead protection goes back further than the frontier. It comes from a belief that no court and no creditor should have the power to take the roof from over a family's head. Spanish colonial law codified it in the 1500s. The Republic of Texas enshrined it in its Constitution in 1839. And today, every single state in America offers some form of homestead protection. Then the lending industry calculated something that made this document very inconvenient. American households carry over $17 trillion in mortgage debt and $1 trillion in credit card debt. Creditors use the threat of home seizure as leverage to force payment on unsecured debts. A filed homestead declaration removes that leverage entirely. If your home equity is protected, a creditor with an unsecured judgment has nothing to seize. And a debtor who cannot be threatened is a debtor who negotiates from strength. They did not stop this protection from existing because they could not. It is constitutional law. They simply made sure you would never hear about the 5-minute filing that activates it. This is the story of the Homestead Declaration, the cheapest legal shield in America, and the document the lending industry has spent decades making sure you never file. Welcome to Channel. If these stories matter to you, hit subscribe and the bell. This is where we open the files the fine print was designed to bury. Now let me take you back to where this principle was born. The idea that a family's home must be protected from seizure is one of the oldest legal concepts in Western civilization. In ancient Rome, the domus or family home held a sacred legal status. Roman law recognized that certain property was exempt from debt collection because destroying a family's shelter destabilized the entire social order. Magistrates routinely excluded the primary residence from asset seizures during debt proceedings. In medieval Spain, the fuero system of local laws granted families protection for their homestead against feudal creditors. When Spanish colonists brought their legal traditions to the Americas, they carried the homestead principle with them. The Republic of Texas was the first sovereign nation in North America to enshrine unlimited homestead protection in its Constitution in 1839. Article 11 declared that the homestead of a family shall be protected from forced sale for the payment of all debts. When Texas joined the United States in 1845, its protections remained intact. Other states took notice. By the 1850s, over half the states in the Union had adopted some form of homestead exemption. The Federal Homestead Act of 1862, signed by Abraham Lincoln, is the most famous expression of this principle. It gave 160 acres of public land to any family willing to settle and improve it. But the lesser-known legacy of the homestead movement is the state-level protection laws that shield existing homeowners from losing their property to creditors. Today, all 50 states, plus the District of Columbia, offer homestead exemptions. But in many states, the protection is not automatic. You must file a declaration of homestead with your county recorder. If you do not file, the protection may not apply, and the filing costs less than $30 in most counties. Before I go further, everything I have revealed barely scratches the surface of what has been hidden from ordinary homeowners. I spent months gathering the financial defense strategies, the legal protections, and the asset shielding techniques that the lending and legal industries never explain to the people who need them most. All of it is inside the complete vault, the Homestead Declaration template ready to customize and file. The anonymous LLC formation guide, the debt validation letter, the spendthrift trust blueprint, the tax classification strategy, over 10 guides in one place, no filler. Every page built for immediate action. The link is in the description right now. But stay here because the legal mechanics of this filing are about to make the creditor industry very nervous. Here is how the Homestead Declaration works at the legal level. When you record a declaration of homestead with your county, your primary residence receives a statutory exemption that protects a specific dollar amount of equity from creditor claims. The exemption amounts vary by state. Massachusetts protects $500,000 with a filed declaration. California protects between $3,000 and $6,000 depending on the county median sale price. Minnesota protects $45,000. Florida and Texas offer unlimited homestead protection regardless of equity value. A home worth $2,000 in Florida with $15,000 in equity is 100% protected from creditor seizure. This means if you're sued and a judgment is entered against you, the creditor cannot force the sale of your home to satisfy that judgment up to the protected amount. If your state protects $5,000 and your home equity is $45,000, the creditor gets nothing from your house. The equity stays yours. The practical impact is staggering. In bankruptcy proceedings, homestead exemptions determine how much of your home you keep. Without a filed declaration in states that require it, you may lose equity that would otherwise have been protected. Bankruptcy trustees actively look for homeowners who failed to file because unfiled protection represents recoverable assets for the creditor pool. A 2019 study published in the American Bankruptcy Law Journal found that homeowners who filed homestead declarations before bankruptcy retained on average $27,000 more in home equity than those who did not file in states requiring a declaration. That is $27,000 protected by a $5 document most Americans do not know exists. If you have made it this far, you already know more about homestead protection than 99% of American homeowners who have never filed the single document that shields their largest asset. Subscribe and share this with someone who owns a home and has never heard of a homestead declaration. Everything the lending industry prays you never file is inside the vault. Link in the description. Now stay with me, because the filing process is almost insultingly simple. Step 1. Determine your state's homestead exemption rules. Search your state name plus homestead exemption or visit your county recorder's website. Check whether your state requires a filed declaration or provides automatic protection. Florida and Texas provide automatic unlimited protection. Massachusetts and California provide enhanced protection when you file. Step 2. Obtain the Declaration of Homestead form from your county recorder's website. It is typically 1 to 2 pages. Some states call it a homestead exemption form. Step 3. Fill out the form with your full legal name, your property address, and the legal description of your property found on your deed or county assessor's website. Step 4. Sign the form in front of a notary public. Most banks offer free notary services. Step 5. Record the form at your county recorder's office. Walk and hand them the notarized form and pay the recording fee. In most counties, the fee is between $5 and $30, total time. Under 30 minutes, total cost. Under $30, including notarization, total equity protected, up to $6,000 or unlimited depending on your state. Compare that to an asset protection attorney charging $5,000 to $15,000 to create a trust structure. Compare that to the $54,000 average lawsuit judgment that could force the sale of your unprotected home. Compare that to a bankruptcy trustee seizing $27,000 in equity you could have shielded with a one-page form. Now, I need to be completely honest with you about the limitations, because this filing is powerful, but it is not a magic shield against everything. A homestead declaration does not protect against your mortgage lender. Your mortgage is a voluntary lien you agreed to. If you stop paying, the lender can still foreclose. The homestead protects against unsecured creditors and judgment holders, not your mortgage company. It does not protect against IRS tax liens, federal tax debts attached to your home regardless of homestead status. It does not protect against mechanics liens in most states. If you hire a contractor and do not pay, the contractor can lien your property. Protection amounts vary wildly. Some states protect as little as $5,000, which provides minimal real-world benefit. Know your state's amount before relying on this. And critically, in states that require a filed declaration, the protection does not exist until you file. If a judgment is entered before you record your homestead, the creditor's claim may take priority. This is not a document you file in an emergency. It is a document you file today, so it is already in place if an emergency comes. The consumer lending industry generates over $800 billion annually in interest revenue. Credit card companies alone collect over $120 billion per year. A significant portion of the collection leverage creditors hold over American families comes from the implied threat that a judgment could force the sale of the family home. A filed homestead declaration neutralizes that threat for less than the cost of a fast food meal. A debtor whose home is protected negotiates from strength. A debtor whose home is exposed accepts whatever terms the creditor dictates. The Republic of Texas understood this in 1839. Abraham Lincoln understood it in 1862. The framers of your state's constitution understood it when they wrote the exemption into law. The protection exists. It has always existed. It is sitting on your county recorder's website right now, waiting for you to download, print, sign, and file it. The only reason you have not done it yet is that no one who profits from your vulnerability has ever had a reason to tell you. If this vault changed how you see the home you're sitting in right now, subscribe and share this video. Every share puts a legal shield into the hands of a homeowner who does not know they are exposed. The next vault opens soon, and what is inside is the one thing every American throws away that could protect their family's future.